Folks, hello, and welcome back to another CCS interview series video. And I'm very happy to be here with the wonderful Lisa Weber of Weber Law to talk about the Supreme Court of Canada's C-92 decision, which just dropped last week. So first of all, Lisa, thanks very much for joining us today.
Thank you for having me.
So, Lisa, it took a long time. It took about 14 months from hearing to decision, but we finally have a decision in this C-92 case, which was basically all about a federal law concerning Indigenous self-government rights with respect to child and family services. So to kick things off, maybe you could tell us a bit about this federal law that's at the center of the case, including why it's so important for Indigenous communities across Canada.
Sure, thank you. So I'll first of all just say what I'm sharing. It's my perspective. I do pretty much predominantly all of my practice is working with mostly First Nations who are at their various stages of reducing their laws to writing and bringing their laws into effect and taking back jurisdiction for child and family services. So much of what I'm going to say is really from that perspective, Richard, although I certainly have read the decision, as you say, long awaited. Everybody was waiting in great anticipation for what that ruling would be. So it was released last week, 100 and some pages, as Supreme Court decisions often are. But I think from my perspective, I would say the act itself, as we know, we'll talk a little bit about it. It was a challenge by the Quebec government challenging the constitutional validity of the act, and it'll be referred to as Bill C-92. You'll often hear it referred to as such in most circles. So the act itself, or Bill C-92, I would say a few things it does. It sets out some specific national standards that apply and have applied since January 2020 when the act came into effect. And those standards apply whenever child and family services are being provided to an Indigenous child, regardless of where that child lives. It's just whenever services are being provided, those standards need to be taken into account. And that's in addition to whatever provincial or territorial standards may be being considered with respect to those services for that child. The second thing, big thing, if you will, that the Act does is it is a representation of Canada's recognition of the inherent right of Indigenous peoples to so legislate and make their own laws, codify their own laws, and then to administer those laws and take jurisdiction for their own child and family services according to their laws. So that's the second thing that the Act does. The third thing it does, and that's related to that second component, is that Bill C-92 establishes a pathway, we say, in saying that this is Canada's pathway within which First Nations or Indigenous communities can take jurisdiction, and it contemplates what's called coordination agreement discussion. So it really is a pathway for those negotiations to occur with the three governments at the table to really envision how is this transition going to occur, including what funding or financial needs are going to go with that transfer of jurisdiction. Yeah, I would say those are the main things that come to my mind as to what the Federal Act does.
No, you mentioned this already, but despite the evident importance of this federal law, the government of Quebec did challenge it back in 2019, late 2019, and it did so by sending what's called a reference question to its provincial court of appeal. And basically, its claim was that the federal government did not have jurisdiction under the Constitution to pass that law. So, what were Quebec's main arguments in support of that claim?
My read of the Quebec's challenge were twofold. The first grounds was that Quebec said, Canada, you do not have the authority to enact legislation which in effect impacts how provincial governments and territories can deliver child and family services for Indigenous children. Basically, they said that's provincial jurisdiction. Federal government, you cannot do, you don't have the authority to or jurisdiction to interfere with that. And I'll go back to what I was saying about the purpose of the act, what the act does. Those national standards establish as I say, standards with respect to how services will be delivered. And so Quebec said, no, that is outside your jurisdiction. You can't tell another government how they are going to deliver those services. So that was the first thing. And then the second thing, second aspect was that Quebec argued that the effect of the federal legislation in saying that it's a recognition of the inherent right of self-government, that exceeds Parliament's jurisdiction. Quebec is basically saying in doing so, that is undermining or altering the constitutional architecture of the Canadian Constitution. So that was their second grounds. And basically, Quebec, as you say, was a reference question asking, is this legislation constitutionally valid?
So let's flash forward in time now, and I want to just skip over the Quebec Court of Appeal judgment from 2022 and go straight to the Supreme Court of Canada judgment that came down exactly a week ago today. And my question here is simply, what did the Supreme Court say? How did it think through and respond to this challenge from the government of Quebec?
Mm-hmm. Well, I think, notwithstanding that it's a 101-page decision, I think the court is stayed within the reins, if you will, of what were they being asked, and they did stick with those questions. Is this legislation valid? They said, yes, it does. It falls within the jurisdiction of the federal government pursuant to Section 9124, which is the provision that says the federal government is responsible for Indians and lands reserved for Indians. And so therefore, legislation which relates to First Nations, Inuit, and Métis children being Indians under the Constitution Act, that's within the jurisdiction of the federal government to so enact. The second piece, I found it interesting because my read of the Supreme Court decision regarding the Indigenous right of self-government, I read it as they are characterizing and discussing it in the context of Parliament's affirmations of Indigenous people's right of self-government. And so they say, yes, Canada, the Parliament does have that authority and within its jurisdiction to enact within its own legislation. It's affirming that. It's affirming the right to do so. And that is also constitutional. So with respect to the Section 35 argument, I obviously don't have the reference to the paragraph, but they do say, we don't need to answer that question here. This is a reference question. We don't want to basically create answers that are going to, in other words, generate more questions. And so they basically say, that's not the question before us. That's, perhaps something that'll be dealt with in other cases. But with respect to the constitutionality of the federal legislation itself, they said it is entirely constitutional and upheld.
So I want to pick up on that last point and move a little bit further with it. So there was an opportunity here for the court to say, yes, Indigenous people have a generic constitutional right to self-government with respect to child and family services, but the court hesitates to go there. And to channel that into a question, what do you make of that hesitance? And do you have a sense of this as a missed opportunity, or do you think that there were any good reasons for the court taking that maybe slightly more cautious, incrementalist approach?
I would say that the cautious approach in this case was probably the better approach to take. Simply from strictly a question and answer perspective, that is not something they were asked. And so consequently, in my opinion, in their response, their response falls squarely with what they were being asked. Was it a missed opportunity? Perhaps. However, it doesn't change the fact that we do still have that Quebec Court of Appeal, which actually had, if I recall, quite an extensive analysis of that argument on Section 35. And so I don't think I didn't perceive in this decision for the court to be taking that active role in that respect, but I think that's okay because I think if the intent of the reference question was to provide clarity around, is this legislation constitutionally valid? yes, it is, and that they answered that question. And so I think from that perspective, the decision is a good one.
Okay, well, I only have one more question, but I think it's the most important one. Because, constitutional law, people like me love to get lost in the weeds of doctrinal analysis and political theory and all that good stuff. But what really matters always is what happens on the ground, and what actually changes when these decisions come down. So my question here is simply, what difference does this decision make for Indigenous people and peoples across the country?
Well, as I said, pretty much all of my work is with First Nations as they're, asserting jurisdiction, taking jurisdiction, and reducing their laws to writing. And I can say they are satisfied with the decision, and really from the time that the Court of Appeal decision was first rendered, I think there was a significant period of time where there was a sense that it was a significant distraction, because we had nations at the table with Canada and with the provinces, and progress was being made. And unfortunately, consequently, when everything was up in the air, waiting for the Supreme Court decision, tables didn't come to a complete halt, but certainly it was a very significant distraction and hesitation as to where things were going to go. And so I think having a decision, number one, having a decision is a very good thing to do. So we're having an opportunity to then evaluate how the decision impacts those discussions. Number two, having a decision as has been written is also very good, because it's unequivocally the legislation is constitutionally valid. And I think the fact that the Supreme Court is saying that this is Canada's affirmation that it is recognizing the right of Indigenous peoples to legislate and take jurisdiction, that in itself is a very positive reaffirmation, I think, for First Nations in relation to them coming to the table really from the perspective that they have inherent and continuing treaty rights to this treaty relationship with the Crown. And so it's looked at very positively in the sense that, okay, that this is what Canada says. We know that, we hear this at the table. Now we have a decision where the highest court in Canada has confirmed that this legislation is valid. The last part, I think that for me and for my clients that I'm working with, that has very much stood out for this decision. Again, I can't remember the paragraph, but there's a comment that the court makes a statement that the legislation is a step towards changing or adjusting the attitude underlying the actions of the governments at the table. And so there's a direction, in my opinion, sort of a message by the court that they're hoping that the decision will really instigate new attitudes and approaches to those discussions. And I should also say the other aspect of the decision is really sort of bookending the legislation, saying that this is a reflection of the international law, UN Declaration on the Rights of Indigenous Peoples. So they nicely bring that all together. And in the end, really what Indigenous people are looking at is the honor of the Crown and continuing in those good relationships.
Lisa, that was wonderful. Thanks so much for joining us and for walking us through this really big, complex, monumental case.
You're very welcome.